Good morning, students. Today I am going to discuss about the right of private defenses under Bharatiya Nyaya Sanhita 2023. In previous lecture, we already discussed about the general exceptions. So, when we discuss about the right of private defense, first of all, I would like to share that what is mean by private defense. So, in dictionary language, private defense means action taken in reasonable defense of one's persons or property. But in simple language, we can say that whenever the person himself or other one or their property is in danger situation, in that circumstances, person having right to take a law in their hands and to do protection of that property, and he having right to protect the ourself or other person also, that is called the private defense. The term private defense and self defense are the interchangeably, and in general sense we can say that to protect from something means in exceptional circumstances when people having no such type of choice to take the protection from the other side. So in that circumstances, person can use their self defense and protect themselves. The right of private defense under Bharatiya Nyaya Sanhita is a defense which a person exercises to protect one's and other bodies and property. So, Bharatiya Nyaya Sanhita provides some specific grounds कि in what circumstances person having right to use their private defense. So, in simple language, we can say that private defense means to protect oneself or to protect our property for something danger. The right of private defense is essentially a preventive right and not a punitive. It means that it's a preventive right. Preventive means prevention is better than cure. If suppose my property is in danger, so for the purpose of that to prevent that property, I have right to use the private defense. But in that circumstances, my intention is clear to protect the property, not to give the punishment of that person. This right ensures the safety of one's own private body or property against some specific offense. There are some offenses. Against that offenses, we have right to use our property as well as our body. This is the right available to any person to protect anyone's body or property against such person. It means that this right is very wide. Yes, by way of using the private defense, we can protect our property as well as others' property, and we can protect ourselves and others one also. It means that if one person is in danger situation, that person is not connected with us, but we have right to protect that person also under the private defense. It must be noticed that there must be a no plan of action and the power utilized must not be more than the required power, and that is needed to ensure the safety of the body or property of the individual. So in that situation our intention is very clear कि in the good faith we have only intention to protect the property or to protect the oneself. It means that before using that right of private defense, we have no such type of plan of action, or we can't use the more exceed power. That is means because here we have intention to protection. We don't have any intention to punish that person, so that's why we want to use the minimum power which is required in that situation. So, the right of private defense is briefly discussed under chapter 3rd of the Bharatiya Nyaya Sanhita 2023. Let's discuss one by one. So, first, you know very well, this concept that is private defense is already available in Indian Penal Code also. Section 96 to 106 define the right of private defense and property. And now in BNS section 34 to 44 speaks about the same. All concepts are same, and the concept of private defense we borrowed from the Indian Penal Code as it is. This section authorizes a man to use necessary force against a person who assaults him. Immediate assistance from the state machinery is not readily at the moment available, and in so doing, he is not answerable in law for his act. In simple language, we can say that it is the duty of the state to protect the person or property. But there are some exceptional circumstances where we don't have any assistance from the state machinery. And at that circumstances, it is mandatory to use the right of private defense. And if suppose we use, so we are not answerable in the court of law because we are using that right of private defense for the protection of property or the protection of the body. So that is the concept of right of private defense. These are the basis of the right of private defense. This right can be exercised against unlawful hostility. Means whenever the person commits such unlawful activity, yes, we can use the right of private defense. It rests with the individual to secure himself and his property against such lawful hospitality. It means that when the person wants to protect their property as well as protect their body, so we can use the right of private defense. When the prompt guide from the state is not accessible and when individual is looked at with the risk, that individual qualifies to use the private defense. Means whenever the person are in the danger situation and he having no such type of that is called the alternative to use the right of private defense. So for the protection himself, he can use the right of private defense should not be exercised with malicious intention. That is very important thing. Whenever we want to use our right, that is the right of private defense, we must always use in good faith. At that time, where intention is clear, we want to use for the protection, not for the punishment. Means there is no scope for the guilty intention or mens rea. The right must be used in sensible manner because only limitation is that we want to protect ourselves or property. So we don't want to more harm to do the more harm that person. So it means that we can use that right in sensible manner. The force used for private defense and threat should be proportionate manner. Yes, how much force want to use to protect ourselves, so we can use. Exceed force is not allowed while using the right of private defense. The right cannot be exercised against the community worker acting in exercise of their legitimate force. Sometimes happens some community workers are using their legitimate force. In that circumstances, we don't have right to exercise our right to private defense. So these are the basis of the right of private defense. Then let's see one by one section 34 to 44. First is a things done in a private defense. It is section 34 is clearly says that nothing is an offense which is done in exercise of the right of private defense. It means that whenever the person is doing anything at the time of exercising of right to private defense, there is no offense because that person having no guilty intention, he having only intention to protect himself or to protect the property. So whatever he wants for the protection of the property or protection of the body, he can do, and there shall be a no offense. That is section 34. Then section 35 says that every person has right subject to restriction contained in section 37 to defend. Whenever we want to use the section 34, it must be read with the section 37 because section 37 provides some restriction ki in what circumstances we can't use the right of private defense. The first, his own body or the body of any other person against any offense affecting the human body. We have the list. There are so many offenses affecting the human body, and in that circumstances, for the protecting of our own body, or protect for the protecting of the body of other person, we can use the right of private defense, of course, by following the restrictions given under the section 37. Then secondly, property whether movable or immovable of himself or any other person against any act which is an offense falling under the definition of theft, robbery, mischief, criminal trespass, or which is attempt to commit theft, robbery, mischief, or criminal trespass. So in simple language, we can say that whenever our property, whether that property is movable or immovable, that is immaterial. And if the offense like the robbery, theft, mischief, criminal trespass is occurred with that property, so it is our right to save that property from such offenses. But again, we want to follow the restriction contained in section 37, means we have right to use the right of private defense for the protection of our body, protection of the other's body, to protection of the property from the specific offenses. Then, in this case, define the nature of right of private. What is the nature of right of private defense? This is the Shankar Balu Patil versus State of Maharashtra 2008. In that case, Honorable Supreme Court stated that right to private defense is purely preventive and not offensive, retributive, or punitive. We already discussed कि our aim while we use the right of private defense, our used to protect someone, protect the body, protect the property. Means it's a purely preventive. Whenever we use the right of private defense, we don't want to punish that person. So it is the right of the purely preventive. Then section 36, right of private defense against the act of person of unsound mind. You might be remember in earlier lectures we already discussed कि whenever the unsound mind person commits any offense, that person is not liable for the punishment. But here our right कि whenever the unsound mind person doing such act against ourselves, so yes, we have right to use the private defense against the act of that unsound mind person. Illustration: Z, under the influence of the madness, attempts to kill A. Z is guilty, no offense, because general exception says that due to insanity, that Z having no sense what is good, what is bad. But A is a sane person, to A having the similar right of private defense which he would have if Z were the sane. So in simple language, we can say that we can use our right of private defense against the act of the person of the unsound mind also, which is defined under section 36 of the BNS. Then section 37 says that which action to right of private defense does not extend. You might be remember in section 35 we says that while using the section 35 we want to follow some restriction. So that restriction is given under section 37. One, act of the public servant not causing apprehension of the grievous act. So in simple language, whenever the public servant doing some activity, but in that activity there is no such type of apprehension of grievous act, we can't use the right of private defense. Second is act done under the direction of public servant not causing apprehension of death or grievous. Suppose some action is there, but that activity is directed by the public servant, and in that activity there is no such type of causing apprehension of death or grievous act, we have no right to use the right of private defense. And where there is a time to have recourse to protection of the public authority, yes, that is very important. We have the sufficient time to appear before the police officer or any other person to take the help to protection of that property or to protection that person. So in that circumstances, we have no right to use the private defense, because what is the aim of the right of private defense? Ki in exceptional circumstances where our life is in danger, where our property is in danger, and there is no such type of that is called the alternative to use the right of private defense, but we have the sufficient time to contact with the public servant. So in that circumstances, we don't have used the right of private defense. So these are the limitations given under the section 37. In what circumstances we can't use the right of private defense. Then section 38, when the right of private defense of body extend to causing death. Yes, though the right of private defense is in a preventive nature, but in exceptional circumstances, while using the right of private defense, if suppose someone caused the death, so that is also excusable. But of course, while using that, we want to follow the restrictions given under section 37, we already discussed. And apprehension must be reasonable and force inflicted must be proportionate. Means sometime happen कि we use the right of private defense, है ना? And in that circumstances, sometime happen कि that person may be dead. Yes, it is excusable, but in that situation, apprehension must be reasonable or force inflicted must be a proportionate. So yes, we can cause the death of that person to protect our body or to protect our property, but section 38 specifically speaks about the protection of our body. Then the right of causing even death of assailant, these are the examples. In that circumstances we can commit the death while using the right of private defense when the assault cause reasonable apprehension of the death. If suppose in my mind there is an apprehension arise, if suppose I did not commit the death of that person, so maybe I will be a dead. So in that circumstances, I can use the right of private defense up to the death of that person. When the assault causes reasonable apprehension that grievous hurt may be consequences such of assault. Yes, is if such type of apprehension arise in the minds of the person ki grievous hurt may be arise, so in that circumstance death may be happen. When the assault is done with the intention of committing rape, gratifying unnatural lust, kidnapping or the abducting, in that circumstances also, for the protection of that person for such type of specific offense, we can commit the death of that person. Wrongful confinement of person in a such way that he would unable to have recourse to the public authorities for this release. So in that circumstances, we have right to causing the death of the assailant while using the right of private defense. This is section 38. Then section 39, when such right extend to causing any harm other than the death. Section 39, section 38 speaks ki in what circumstances we have used right extend to death of that person. But section 39 says that ki we have right to use any harm other than the death. I mean, in that circumstances, we can't commit the death of that person. If the offense be not any description specified in section 38, means only which explanation given under 38, we have right to use the right of private defense up to the death of that person. And specifically while using that right of private defense, we must follow the section 37 restriction also. Otherwise, we can use the right of private defense causing to harm but not to death. Then section 40, commencement and continuance of the right of defense of the body. Ki, how much that such type of right of private defense is there. So when the right of when the apprehension of death arise in the minds of the people and up to the end of that apprehension, yes, that person has right to private defense used till the minimize or till the extinguishment of that right, that is the danger. Then section 41 speaks about the right of private defense of property extend to causing death, just like as section that is called the section 39 speaks about the body, and section 41 speaks about the property. Right of property defense of property extend under the restrictions specified in section 37 to the voluntarily causing of death or any other harm to the wrongdoer if the offense, the committing of which or attempting to committing which occasion the exercise of right to any offense of any description hereinafter enumerate. It means that while using such type of right against the property, we want to follow the restrictions given under the section 37. So these are some offenses. Ki robbery, house breaking after sunset and before sunrise, mischief by fire or any explosive substance committed on any building, tent, vessel, which building, tent, vessel is used as a human dwelling or as a place of custody of property, theft, mischief, house trespass under such circumstances as may reasonably cause apprehension that death or grievous hurt will be consequences if such right of private defense is not exercised. So these are some offenses where if our property is in danger and for the protection of our property from the robbery, house breaking, mischief, theft, house trespass, so in that circumstances we have right to use the private defense up to the death of that person offender, of course, after using the section 37's restrictions. Then section 42, when such right extend to causing any harm other than death, just like as yes, we have right to use the our right of privacy extend to causing any other harm, but section 42 says that those offenses mentioned in section 41, for that purpose we can use our right of private defense extend to death of the offender, but other than we can't use our right of, we can do any harm, but we can't do the death of that person according to section 42. Then section 43, commencement and continuance of right of private defense of the property. So commence when reasonable apprehension of danger to property commence, against theft continue till the offender has affected his retreat with the property, either the assistance of the public authorities obtained or property has been recovered. Means this is the continuation process. Ki if our property is still in danger and it is the reasonable apprehension arise in our mind ki our property is destroyed, so our right of private defense is also continued till to save that property, which is given under section 43. Then against robbery, against criminal trespass and against housebreaking also. Then right of private defense against deadly assault, well there is a risk of harm to innocent person. Sometime happen, we want to use our right of private defense against that person who commits the offense, but while using of that right of private defense, there is a possibility to do harm any innocent person. There is a risk of harm to innocent person. It is excusable because we have no such type of mens rea to do harm that innocent person, but in that situation without harm that innocent person we can't use the right of private defense. So in that circumstances it is our duty to protect that person, but in exceptional circumstances for the exercising of our right, it is possibility that there is a risk of harm to the innocent person, which is defined in section 44. If in the exercise of the right of private defense against an assault which reasonably cause the apprehension of death, a defender to be situated that he cannot effectively exercise that risk without risk of harm to the innocent person, his right of private defense extend to running of that risk. So it is allowed, which is defined in section 44. Then this is the illustration. A is attacked by a mob who attempt to murder him. He cannot effectively exercise his right of private defense without firing on the mob, and he cannot fire without the risk of harming young children who are mingled with that mob. A commit no offense if by so firing he harms any of the children, because it is a possibility that when that person is fired on that mob to protect himself, so maybe maybe some child may be injured, so it is excusable. Then there is one case law, that is the Sukumaram versus state. That is very important case regarding the private defense. The Supreme Court in this case acquitted the Tamil Nadu forest ranger who was accused of killing a sandalwood smuggler in certain forest area by shooting him. In that case, court observed that a right embraces the protection of property, whether one's own or another person, against offense like theft, robbery, mischief, criminal trespass, where a reasonable apprehension is enough to put the right of self-defense into the operation. We already discussed that whenever the apprehension arise in our mind, that person may commit any activity which is destroy our property. So in that circumstances, we have the right to use the self defense. So in that case, that foster ranger used the that person smuggler who tried to steal that sandalwood. So in that circumstances, that person is acquitted by the court. And then that is the case we already discussed. Then Darshan Singh versus State of Punjab 2000 case. So the Honorable Supreme Court lays down some guidelines regarding from the right of private defense. It is observed that person cannot be expected to act in a cowardly manner when confronted with an imminent threat to life and has got every right to kill the aggressor in self-defense. While acquitting a person of murder, court said that by enacting section 96 to 106, because case was happened in the 2010, and at that time BNS was no there. That's why the section 96 to 106 of IPC is there. The legislature clearly intended to arouse and encourage the spirit of self-defense amongst the citizen when faced with the grievance danger. So, in simple language, in that case also, Honorable Supreme Court say that every person has right to life. So, for that purpose, to protect our life, it is our duty to use the right of private defense. Then this is conclusion, you know very well. Private defense is an excuse for any crime against the person or property. It also applies to the defense of stranger and may use not only against the culpable but against the innocent aggressors also. The defense is allowed only when it is immediately necessary against threatened violence. A person who acts under a mistaken belief in the need of defense is protected, except that the mistake must be a reasonable. The right of private defense is not lost by the reason of the defendant having refused to comply with the unlawful commands. Force used in the defense must be not only necessary for the purpose of avoiding the attack, but also reasonable, that is, the proportionate to the harm threatened. The rule is best stated in the negative form that force must not be such as a reasonable man would have regard as to being out of proportion to the danger. So, in simple language, at the time of conclusion, I must say that the right of private defense is one of the right which is used by every person where when the property is in danger or himself or others one is in danger. So this is overall introduction about the right of private defense. Thank you.